the flow that I have in mind, and I would love to have question answers towards the end, because I intend to present to you some of these examples and anecdotes for about 40 to 45 minutes. And we are starting at 2:50. So I'm going to be targeting 3:35 or 3:40, by which I would have finished my presentation, and then I'll be open for questions so that we are still on time and we don't slide too much. So the flow that I have in mind is I'm going to first give you examples about how intellectual property has been helpful in career building for students, under which I will talk about scholarships, under which I will also talk about students getting jobs and getting funding for their startups. The next important bullet is about how IPR is becoming more and more relevant in the industry. And mind you, this was really not the case a decade ago, especially in India. And nobody really gave any serious thought to intellectual property. And in last 10, 12 years, things have changed quite a lot, as we get into the deep learning, neural networks, and some of the other things that I will also be talking about. This has become very, very important. The third component is simpler, and that is actually building your career in the IPR area. So thinking about being a patent agent or a patent examiner, patent analyst, and there are quite a few of those amongst us in this conference. And then I definitely want to talk about newer directions in agriculture and how they present IPR opportunities to the students and also the faculty who are participating in this conference. And towards the end, if time permits, I do want to talk about an app that we have built called Career Clock. And in fact, we have filed for an Indian patent for that. And it is something that will be very useful for the students in building their career, in updating their career, and it uses artificial intelligence at its back end. So this is what I intend to present to you with few examples. Before we get into the examples, I know you have gone through in many detail about what intellectual property is and what are the different types of intellectual property. So I'm not going to be talking about that because I think not only you know these, but you have gone in reasonable details and depth of each of these. In fact, I know that the content of the conference did have an entire session on geographical indicator. So why I wanted to share this slide before we talk about some of the examples is these are 7 opportunities for the students to build something in their resume and also build something in their portfolio if they are thinking of starting their own business. And I'll give you examples where students were able to do this. So even if you have a trademark, even if you have a trade secret, or even publication, that can really propel your career very nicely. And copyright patent obviously are very, very important in that area. Now, many a times when I have worked with students and I have written and filed about 100 plus patent application for students. And I'm happy that I'm today talking to CSK Himachal Pradesh Krishi Vishwavidyalaya, Palampur. I have also interacted with Assam Agricultural University in Jorhat about 6-7 years ago. And a similar kind of session I had conducted in yet another agricultural university. And we did talk about patents and copyrights and trademark. I think for agricultural university, last time when I had that kind of interaction, and also with some students in Krishi Vidyalaya Rahuri, Mahavidyalaya Rahuri, I'm pretty sure you are aware that in Maharashtra, in Marathwada, there is a university, and that is a very famous university. In fact, It's definitely in top 5 in India. And some of my students come from that university, and we keep discussing and talking about all of this intellectual property minus the geographical indicator, because geographical indicator is a no-brainer as far as um agricultural university is concerned. But people keep wondering whether patenting and copywriting are really for agriculture. And the emphatic answer is yes, they are. I'm going to give you some examples. And by no stretch of imagination, agriculture is excluded from the ideas of patent because of the technological changes. Those are happening, and we'll be taking a look at that a little later. But those changes are in fact widening the horizons as far as specifically patenting is concerned with respect to agriculture. So I think I do want to thank the organizers of this workshop. I do want to thank Tripti, Dnyaneshwar Mulay sir, who I have known for some time, Dr. Sood, and of course Dr. Jayashree and Madhuvanti, who have been the driving force behind this conference. That we are talking about intellectual property for agricultural university at a very opportune time. So while working with the students, I have found that many a time students are not, they come up with an idea, but they are not sure whether it is novel enough. And so I just want to give one quick example, which is a very simple example on a lighter side, but I think it will still showcase the important point. So this is an example. There was a patent application that was filed, and the title was Method of Raising Sunken or Stranded Vessels. And this was filed in UK, in Germany, and it was also applied in the Netherlands. And this patent was actually granted. The numbers are given in the box. And while it was being assessed in the Netherlands, as you now know from the presentation of Dr. Jayashree, that there are different stages in which the evaluation takes place. That time, while the patent was granted already in the UK and Germany, and I think there was one question from the student to Madhuvanti in the previous session: if you have a patent in India, then is it automatically protected in the other countries? And I think Dr. Jayashree responded that you will have to file for a PCT. So this is again reflected here, that there was a patent that is granted in the UK and Germany, and it had to be a separate application in the Netherlands. And there the claim was buoyant bodies, which are shown in the diagram. 1 are inserted into a sunken vessel 4 through a tube 3 from a salvage ship. This is basically to raise a sunken ship, which might be carrying very disastrous oil. And so you have a salvage ship and you raise the sunken ship by forcing buoyant bodies into the sunken vessel. Very simple idea. And it's not equal to MC square. And most of the patents which are granted, applied for, are 99%, I would put it at, as just incremental patents. So this is one of those classic examples. And the inventor, Kroyer, had applied for Dutch patent, and it was rejected. And why was it rejected? Because of Donald Duck. There was a magazine of Donald Duck, and it talked about Donald Duck pumping the ping pong balls into a sunken ship. And even though this is not a technical journal, I'm sure you all recognize that Donald Duck magazines are not scientific journals. But because it is already published, and this was published before the date of filing of this patent application, it was considered prior art, or it was considered to be the body of knowledge before the filing date, and hence it was rejected. So the novelty was challenged, and in fact it was destroyed. And not only the patent in the Netherlands was rejected, but subsequently the one that was previously granted in the UK and the Germany were also revoked. So what I want to showcase to the students who are on the call is that the novelty is not something that is born out of only analysis of the technical journals or books that you have at your disposal. It's a much bigger game than that. And hence, I would agree completely with Dr. Jayashree when she said that it would be in your interest that you look for professional help above and beyond what you do normally on Google, right? So this would be quite important for you. But I just wanted to throw this in the mix that even though we are talking about very serious business of intellectual property, it doesn't pertain or it doesn't limit itself only to the technical body of knowledge. It can come from even popular science and popular literature. Okay, so let me go ahead. And the reason I showed this novelty piece is because I have struggled with a lot of students who are sitting on good ideas, but they don't know how to assess the novelty. And of course, as you know, it needs to be useful, it needs to be novel, and it needs to be unobvious. And so the second most important step in patentability needs to be assessed by you first, and then you probably could take it to a professional. So in intellectual property, in career building, the first part which I want to start with. So just want to share a story about a student who came to me during my workshop, which I was conducting in Cummins College of Engineering for Women in Pune. And she said that we had just concluded a session on the importance of IP. And she said, sir, I'm not very, very creative, and I don't think I'll be coming up with any patentable idea. But I do want to give a try to publications. I definitely want to think about the publication route. And she eventually was able to publish about 3 or 4 technical papers, and they were not inventive papers. They were more comparative papers. And even based on that, this lady was able to secure a scholarship in Chicago. And as if this is not enough, the background of this lady, Sophia, she came from Islampur, which is almost like not even suburban. It's not even a town, and in Maharashtra, very close to Kolhapur and Sangli area. And she was one of the very few students who actually graduated, and that too in engineering. So moral of the story is that even publication, which is a type of an IP, is something that you people can think of, both faculty and students, to have concrete development in your career. Let me give another example where a student actually was participating in, there are many hackathons and there are many competitions, technical competitions and so on. And this lady in 2016 was competing in a competition that was and at the intersection of medical field and IT and instrumentation field. And she came up with a very simple design of taking an incision into skin. And she actually used vernier caliper. So very simple way of doing the incision. And eventually we were able to file for a design patent for that. And she graduated in 2017, but before she graduated, she had a design patent to her name. And because of that design patent, not only she was called by a US university to visit them, first for a trip, to assess whether she wanted to work in the group of that professor. But eventually she got a full 4-year scholarship to complete her PhD. And all of this started with a very simple, innocuous, and very rudimentary looking product that she had made. In fact, she told me that based on the product, somebody was even willing to fund the commercial prototype of that. So I don't know if that actually took place or not, but this is the power of intellectual property. Another very simple example I would like to give you is with a student who that time I was working with IBM, and I visited the college. And when I was talking to the student, I felt that what he had come up with was at least a provisional patent application. So I had to really cajole the professor into writing a patent application then. So this is about 2010, 2011 timeframe. And we eventually filed it. And based on that provisional application, now I'm sure you know the difference between the provisional and the final application. and the full application was not even filed, and all we had was a provisional application. 6 months into it, he was able to get a full scholarship in the UK, to the extent that they even sent him an air ticket. Um, there was one more student, the fourth story which I want to share about the importance of IPR in career building, is of a student who wrote a utility patent, and she was not exactly a top scoring student. She had a CGPA of something like between 7 and 8, and she was right in the middle of the class in terms of performance, and she was not able to score very high, and there were at least 100 people, students above her. But still, she was able to get the job, which paid something like 14 or 15 lakh rupees per annum. And they had selected only 2 students. So I think the other student was one of the toppers, and it was her. And the reason they gave, in no uncertain terms, was that she had a utility patent filed to her name. It was not granted, but it was filed in the process. And so these things are more common than you care to think. And so intellectual property will definitely be useful in career building. One case study I want to share with you, something that is closer to your area of work in agricultural university, is while working with Cummins College of Nagpur, Cummins College of Engineering in Nagpur, we filed for a design patent, and it was about a very simple design. It was for hand-operated chironji seed, what we call Charoli in Marathi, which is a constituent of Shrikhand, one of the sweets, very popular sweets. And the decorticator machine of this chironji seed was actually built very rudimentary, very simple, by 3 students who came from Chandrapur area, Adivasi area. And they told that their mothers would go to the forest nearby, and they would collect those chironji seeds, and they would sell that to a grocer in Nagpur, who in turn would open the seeds and sell the final product for almost like 20 times the price that they would pay to their mothers. Now, the 3 girls said to themselves, why don't we build a decorticator machine, thereby saving a lot of hassle for their mothers? And they did that, and it was absolutely rudimentary. And when I saw that, we actually filed for a patent, and Cummins College of Engineering for Nagpur, the first patent that they got was for this design. And in fact, the number is 301100. It was issued on 8th of January 2018. And this started the silsila of patenting activity, and this helped Cummins College of Engineering Nagpur to get NBA and NAC and those type of accreditations as well. In fact, very happy to tell you that larger scale machines were also built subsequently. And I personally went to the government officials who were my students, who were in Adivasi Kalyan department. And I requested them to take these machines to different Adivasi padas, so that the livelihood of these Adivasis would be much better. And something that started as a very simple activity of 3 girls coming to me and talking to me about some obscure looking machine that they had made, even though it was hand operated. Eventually they turned it into a battery operated and electricity operated machine, so on and so forth. But really, the design is something that led to something tangible, something that was useful and very simple. All 3 students who were involved in this, coming from the Adivasi area of Chandrapur, they clearly, I took their mock interviews, and it was very clear that their English was not as good, but they were all 3 of them were able to secure a good job, despite their weaker English, because of the clear demonstration of creativity and clear demonstration of initiative. And so this is what you would find on the website of cumminscollege.edu.in, which is Cummins College Nagpur. And you will also see that they were able to secure 50,000 rupees grant. And that was because they had that design patent filed. And so that is the power of a patent filed and intellectual property. Another example I want to give you is another case study with Cummins College, Pune, and we had filed in 2014 a utility patent, and it was for intelligent design of sericulture. I had filed it myself with four students, and those students, they were able to use the basic concept, what is popular in IT field called cooling of server farms. They use the same principle to intelligently partition the larvae, pupa, and the worm stage of sericulture. And eventually it increased the yield by 4 to 5%. And of course, you know, the cost of silk is very high. And so anything like 4 to 5% improvement in yield would mean 4 to 5% improvement in cost savings as well as revenue, increase in revenue. And that would be a big deal because it runs into crores of rupees India-wide. And it was a significant modification from the basic idea in IT field. So what I'm also trying to point out to you is that some things you might see in some other field, and you may transplant the idea into your field of work or domain, and you can still come up with a design or a utility patent. And to the icing on the cake was that people in Mumbai from Sericulture Board of India actually visited the college, and they showed interest in buying this intellectual property from the college, which had never happened in the history of the college, and they were very pleased. And all of this started again with a very simple, innocuous looking seminar topic or a final year project that students were doing. So what I want to point out to you is that you might actually be yourselves sitting on some good ideas which are patent worthy. It is just question of you evaluating the novelty by yourself and being motivated that you may actually turn this into something more tangible than just having an idea in your mind and just talking about it. Instead of just talking, I would urge you to go ahead and build something on that. Surely, intellectual property is very important for funding. It is definitely an enough asset for securing funding. I've spent about 13 years in the US, and I can tell you for my first-hand experience that many of my friends were able to secure funding for their ideas, even though they did not have any real assets. And I'm also happy with all the politeness that I can garner to tell you that while I was thinking about certain intellectual property, there were offers made to me, to my company for investment. And so these things are definitely common in the Western world. In India, it is definitely gaining more and more traction. And one of my own mentees, actually, he was not directly my mentee, he was my friend's mentee, but we started working with him together. So he got an angel investment of about 25 lakh rupees from a member of TIE, the Indus entrepreneur, based out of Mumbai. And it was based only on the IP that we had filed. So he had not even what is known as the lean product or prototype. He did not have that. And only the idea was there. And it was actually in the area of agriculture. It was that time, it was intelligent control of water drip irrigation for the farm. So this has become now very common, but that time it was quite a novelty. And this was able to get some funding. And in accounting also, if you spend some money in IP protection like copyright and patent filing and so on, then it is considered amortization. And so there are different sections in tax laws which will give you tax benefit. And in fact, we are talking about Atmanirbhar Bharat. We are aware that there is Stand Up India, Startup India, and there are a lot of initiatives which the government is coming up with. And they are, in fact, they have declared in the recent budget that was presented by the Honorable Central Finance Minister Nirmala Sitharaman. She talked about how the tax benefits and SOPs would be given to MSMEs and especially startups. So I think it is in your interest that you think about IPR more seriously. It is not just a topic where you get some grades and pass the exam, or just a conference where 2 days you participate and forget about it. I think it is something that is very central And the more you get into Atmanirbhar Bharat and the current decade, I think there is going to be a lot of responsibility in terms of IPR, especially in the area of agriculture, which gives so much of employment and contributes fundamentally to the GDP of our country. Let me again play a video. I hope you are able to see the video. And this is about pots made from peanut shells. Okay, and there is no sound to it, so don't worry. It's already the script is there. And so there is this lady who started using the pulp made from the peanut shells, and she turned that into a pot. And those pots were left to dry, as it is saying now, and it takes less than 20 days to fully degrade in the soil. And eventually these pots are very useful because they provide the very moisture and nutrients and all of nitrogen, phosphorus and calcium, everything that you people keep studying, the classic NPK. And it is environmentally friendly. It is replacing the plastic. And this is coming from a girl who is not very techno savvy, but she was able to turn this into a prototype at home with her own hands. And now she has, after public demonstration of her invention, she received a few awards, which is not a big surprise. And she got engineers to actually construct this pot making machine for her. And now this can produce 6,000 biopots per month, which is a very viable business. And importantly, Srija, who is this very young lady, has turned something from agriculture to a very practical idea. I'm sure on WhatsApp you run into several of these examples, right? So for students like you who are formal students of agriculture, I think you must be seeing a lot of ideas. And in fact, they say that manufacturing sector, auto sector, etc., are kind of more or less saturated. The areas which are very potent for newer ideas, newer frontiers, one of them definitely is agriculture, and especially in a society like India, or country like India. Now, IPR is important for companies too. If you're not into the entrepreneurship route, and if you're thinking about building your career in a company, still this is very, very advantageous. And the competitive advantage is there for companies. A lot of companies have collaterals or marketing material or branding material built around IPR. So for example, if you go to Starbucks, the cup holder that you see, the cup holder actually bears about 6 patent applications in different continents. And so something very simple as a cup holder, right? Another thing that I would point out to you is it is a very strong deterrent for blatant copying for a very small fee. Blatant copying would not be done by big companies. It will be a definite deterrent. In the NCLAT or NCLT, the tribunal, generally the favor is given to smaller entities. And so the large corporations are very, very wary of at least blatantly copying a simple looking idea, which did not happen with a friend of mine. So the case study is that my friend whose company employed about 400 people in Pune had a yarn spinning machine company, and they had invented something which was sort of an add-on, and they did not file for a patent. They participated in a symposium, and next to their booth was Toyota. You know, Toyota is a big company, not only in cars, but also a variety of machines. They are into spinning, yarn spinning machines. And so they saw the idea and they just simply copied that in the next version of their machinery. And they started selling that here in India, which otherwise would have been the customers of my friend's company. And so my friend, by not having filed a patent, lost the technical edge and actually lost revenue in and around Kolhapur and Ichalkaranji area, which is a very well-known yarn spinning area like Coimbatore. So there is growing awareness in IP about IP in IT and pharma and even manufacturing area. Also genetics and healthcare joining the club now. Being IP aware will definitely increase your market value and you will become an asset to your employer. So think about this very, very carefully, and not only think about it, but I would urge you to act upon it. If you look at creativity as a skill, then in 2015 you are seeing that it was at number 10. In 2020 it got upgraded to third position, and creativity is something that you will amply demonstrate if you have a patent or a publication to your name. And as if this is not enough, after COVID you will see this report which was published in 2020 World Economic Forum. This is after COVID. You are seeing still creativity, originality, and initiative, which is nothing but intellectual property, in top 5. Suffice to say that the intellectual property rights work that you will do and any effort that you will take or in that direction will come to your rescue if you are thinking about entrepreneurship, if you are thinking about taking up a job or even doing research. So think about this very, very seriously. Now let me move on to patent area or intellectual property as a career rather than career helping step. You actually develop a career into IPR. So I just have 3 slides whereby I'll tell you what patent agents, patent analysts, and patent examiners are. Patent agents are basically people who would be sort of intermediaries between the inventors and the government. And so what is a chartered accountant to tax filing with respect to government is patent agent with respect to intellectual property for government. So you will go to a patent agent, explain your idea, and the patent agent will help you in terms of search, in terms of making a decision whether something is patent worthy or not, and what should be the right wording of the claim, and so on, and file a patent for you and seek the process. So patent agent is something that you can also do. And it is very interesting. This is the screenshot I took today of the website ipindiaservices.gov.in. And you will see that the number of patent agents which are available in India, at least on this website, are 4,158. So I'm pretty sure that many patent agents who may not be covered here still do not go beyond 5 digits. And if you think of our population being 1.4 billion and counting, 4,158 is a dismally low number, which clearly says 2 things. One, that we are way, way below what we really need as patent agents as a number for our country. And secondly, because you are from agricultural university, naturally thereby in the science related field, eligible to become a patent agent. And remember, if you are in private sector at age 60 or something like that, depending on the company, you ought to retire. In government also, there is a retirement age. If you are a patent agent, then there is no retirement age as such. You could be working as a patent agent for a very, very long time. So this really builds your career well. Similarly, if you look at patent examiner, which means now you are working from the government side. Patent agent is where you are filing patents on behalf of your clients, which are private sector or public sector. But here, patent examiner is you are examining the patent applications received by the government. And again, this is today's Wikipedia download, and it says the Indian Patent Office has only 526 patent examiners. So that's again a very, very shamefully low number, which also opens the opportunity for you to become a patent examiner and make a mark. Also, the last one is patent analyst, and this is growing number of analysts are required in public, private sector, in companies, in organizations, especially pharma, IT, medical, agri, and manufacturing. We heard that 43,028 patents have been filed in India from 1st of April to 2020 to the end of the year 20. So they are required in more and more in research institutions. They do search, analyze, identify novelty, deciding publish or patent, and formulating the claims. And you are always at the cutting edge. and you will eventually have international demand. There are many of my friends who became patent analysts. They are actively working in the IP area, and while they are supporting their Indian clients, they are actually much more supporting their international counterparts. So I think it would be also very interesting for you to become a patent analyst, if not a patent agent or patent examiner, right? So next 5 or 10 minutes, so that I still finish on time, I'm going to be taking you through some three areas which I think are extremely crucial for students like you to know about vis-a-vis agriculture, and also in light of the intellectual property. And the three aspects which I do want to talk about are Industry 4.0, the advent of 5G technology, which is going to make a huge impact in agriculture. And we also have Industry 5.0, of which bioeconomy is a part, and bioeconomy naturally includes you people. And so I do want to talk about that. So Industry 4.0, quick background, as you must have gauged, Industry 4.0 is a culmination of first three revolutions of industrial revolutions, 1, 2, and 3. Industry 1 revolution, first revolution, took place in the UK, in England, and after that about 100 years passed, and we have 1870, and we have Industrial Revolution 2, which is mass production based on electrical energy. And then another 100 years passed, and in 1969 we have Industry 3.0, which is based on electronics. And in less than 40 years, we have in 2012 we have Industry 4.0, which is based on cyber physical systems. So I'm sure you quickly realize that Industry 4.0 is only a decade old, and we already have multiple versions of Industry 5.0. In fact, I have written one paper on Industry 5.0 and presented it to the Niti Aayog. And there are some newspaper articles which are going to be featuring in the coming week. And we also have made a presentation to IEEE conference very recently. So Industry 5.0 and 4.0 are very central to you. And especially with 5G, we keep hearing about Jio and Vodafone and many other companies, and even the Indian government. If you remember, a lot of energy, a lot of investment has gone into the 5G infrastructure, 5G setup that would be required for India to be taking bigger strides in the decade that we currently are in. So what is Industry 4.0? Industry 4.0 is the next step of industrialization, and you will see in this graph that it's going to be an exponential technology change, which is the example of which is given on the screen. If you look at year 2000, the computing power per 1,000 US dollar was equivalent to that of an insect brain. If you go further up in 2020, which is actually history now, it maps onto one mouse brain. And if you go further up into 2030, then it's going to be equivalent of a human brain capacity. So that's a very scary news for all of us. And 2060 or 2050 and 60, somewhere around that time, the $1,000 USD computing power is going to be equivalent of the human brains, human population at that time, at about 2050. And this is from Bank of America and UBS, and this was published in June 2020. So this is post-COVID. And so remember that if we are going to grow in terms of computational power and complexity of this graph, even if we say that this is probably plus or minus 20% off, it still is a very scary picture. And so technological advancement into agriculture cannot be overlooked, and it will be overlooked only to your own peril. So my request to you, even though this is about IP, that you should pay attention to this. And secondly, this also opens up opportunities in IP. So Industry 4.0 components, I'm quickly going to go through that. Suffice to say that there are 9 of them. autonomous robots, simulation, the cloud, which we are all very familiar with, because when we go to change our phone, we generally download the contact list or photos or videos and many other things from the cloud to our new handset. And so cloud is not new to us. Simulation, of course, you being science student, is not new to you. Big data, nowadays, big data, which is not just the numbers and text, it is also pictures and sounds and videos and so on. So it's multimodal, it is voluminous and so on. There are 5 V's which go into the definition of big data. So that is a very important branch, component of Industry 4.0. Then you have augmented reality, virtual reality. Then you have cyber security, which is we popularly know as data security or blockchain, which is the foundation of cryptocurrency, which also is a foundation of Bitcoin, the one that we keep talking about. And again, recently, just 2 days, 3 days ago, the presentation made by the Honorable Finance Minister talked about 30% tax levy on the cryptocurrency benefits and gifts, etc. 3D printing, just like you have 2D printing, you have 3D printed materials, and there are different techniques, including nanotechnology. You have IoT, IOP, and IIoT, which is Internet of Things. And that also is very important for agriculture, especially in drones, in terms of pesticides and so on. And then the glue that binds all of this is artificial intelligence. This put together is called Industry 4.0. And this is already in action in agriculture. So just quick example is agricultural equipment and manufacturing is being done by 3D printing. IoT is being used for gauging soil data and NPK data. And this has been demonstrated in 2017 by ICRISAT, which is in Hyderabad. And along with Microsoft, they had created a project, a pilot, which increased the yield of the farmers by 20 to 40% in a very short time. And the number of farmers who started participating in that app and portal arrangement grew 10 times. So that's another example of Industry 4.0 used in agriculture. And there are many others. Drones being used for pesticides and insecticides spraying and so on. So really, post-COVID-19, the world has changed, and in the new normal and in the gig economy, I4, Industry 4.0 is definitely going to impact agriculture as well. And this will open up many applications which are at the intersection of agriculture and Industry 4.0 or big data and analytics, and that would be your opportunity to make a dent. So there's a video which I would like to play, and that is talking about use of Industry 4.0 in agriculture. So it's digital agriculture.
The agricultural industry is changing fast.
So let me just show you how these screenshots look like in the interest of time, so that we have some time for question answers. So this is really how in the same space, and at the fingertips you are going to have a very clear picture about what's wrong where and what type of interventions are needed. So those type of things are being shown in this video. This is publicly available video, so you should be able to access that if you want later. But again, the point here is that you will be able to do a lot of stuff digitally, and the IT world is coming closer and closer to the horticulture, sericulture, floriculture, and agriculture in general. So I think it would be in your interest to be aware of that and taking part in the action. So I'm just going to say that there has been yet another term called Society 5.0, which came about in 2017 in Japan. And it is with respect to how the society, first 4 versions of society have evolved, and Society 5.0 really building on the advantages of Industry 4.0 to have solutions for better human life. And to that end, Industry 5.0 has also come about, which has two versions, one about robotics and the other one with respect to bioeconomy. And bioeconomy, again, very something close to your heart, that is about biotechnology, that is industrial biotechnology, and also DNA. So I saw there was a presentation from the genetics side. Dr. Sood is from Department of Genetics. There was presentation yesterday, and we also talked about breeding technology. There was a presentation today. So all of this DNA analysis, CRISPR-Cas9, biocircuitry, xenobiology, all of these things are going to be very central to intellectual property with respect to agriculture. And the last slide, which I want to talk about, is that really Industry 4.0 will have more components. And one of the components is bioeconomy, which happens to be your field, and augmented by synthetic biology. Not just the biolization and not white biotechnology, but also synthetic biology, which will lead to sustainability and renewable resources. So this is what I really wanted to share with you. And as promised, I'm stopping at 3:39. So we have some time for question answers. So I'm going to stop sharing my presentation and open for question answers if there are any. Okay, so I think there is a question how to get all three jobs that you have talked about. What are minimum qualifications for that? Oh, you want to have all three jobs. That I think would be quite difficult, Gaurav, simply because you can't be a patent agent and an examiner, because then you'll have to be on both sides of the aisle, which is not possible. So there are examinations which are conducted at a regular frequency. And I hope it is more of a regular frequency than irregular, because there have been years when they did not conduct, the government of India did not conduct patent agent examinations. And so naturally there was no induction of new people. But they are advertised on ipindia.gov.in, I think. And you can definitely get more information about that from Dr. Jayashree or Madhuvanti, because Madhuvanti is a patent agent, and she actually was working in private sector first, and 3-4 years ago she became a patent agent. So that information is definitely available on the web. But a patent agent you can become by taking a test, patent examiner also the same, and patent analyst is, I don't think there is a test like that, but if you study enough and if you approach companies, then they would appoint you, which happened with me, by the way. And so there was training given, but there was I worked as a patent analyst for IBM, and that time the idea was to use your domain and solve the intellectual property areas. Yeah. Okay, so Virender Kumar, thanks for the kind words. Yes, I think I echo your sentiments that there are a lot of opportunities for agricultural graduates, especially because they are saying, people in the field are saying that manufacturing area, auto sector, and even to some extent IT sector, the application areas are kind of saturated, but agriculture and healthcare are very nascent areas, and that is where the real cutting edge henceforth is going to be. Okay. Yes. So thank you, Dr. Jayashree. Patent agent, bachelor's degree in science, STEM, basically STEM, science, technology, engineering, mathematics is what they require to become a patent agent. So I suppose you being in agriculture, you qualify because you are definitely in science. Yeah. Sir, can we protect synthetic biology products like synthetic genes? What are the scenario for? So synthetic genes can be applied for, but regular genes, if you are able to make, then those are beyond the purview of intellectual property, simply because they exist in nature. So something that is naturally occurring, you can't go for a patent for that or even design. There is a lot of push by the government also, and I'm glad that you are thinking on the genetics lines as well, because if you carefully study the budget that was presented 2 days ago, the Honorable Finance Minister did talk about drone as a service, which is a very new concept, by the way. We have software as a service, we have platform as a service, we have many others, but we did not have until now drone as a service. And you probably have been reading that there are going to be three types of licenses: commercial license, and another one which will really not require a license, but you can start giving service and you can build business around it. So drone is a very important area, not just for agriculture. It is, in my view, general and more generic. And so drone as a service is a very important announcement that we heard just 2 days ago. So that would also be in line with many of these agriculture-based products and services. Any other question? Okay. So I will then hand it over back to Tripti, and I think I have not exceeded my time, I hope, and we are up for the next session. Yeah. Thank you. Thanks for giving me the opportunity, and also great participation from the students and faculty. Thanks.
Thank you. Thank you, Dr. Bhushan. It was such an interesting session and such an informative one, and eye-opening as well, with so much interesting facts and possibilities that IPR holds for the younger generation. And I do believe that the students have been benefited at large with this session. Thank you so much for your expertise. Now,
Thank you.
moving on towards the last session of the day with our expert, Mr. Sarang Winze, who has been awarded Hall of Fame 2018 by Indian Society for Clinical Research. Mr. Sarang is also very interested in developing new processes, process engineerings, and he has participated in Hackathon 2018, an annual event held by IQVIA, and was a grand jury finalist in this event, which comprised more than 100 teams. On personal front, Sarang is an avid blogger and has two blogs, English and Marathi. He likes photography, reading, and listening to music. I welcome Mr. Sarang Winze for his address.
Thank you for this kind introduction. I will share my screen, so just let me know once you are able to see my screen. Are you able to see it?
Yes, it is sharing, and yes, we are able to see.
Perfect. Thanks. We have come to the absolute last session of this two-day workshop on IPR, and it's really nice. Thanks to the organizers for giving the opportunity. And I am going to talk more on the applications of IPR in the real life. So that includes some definitive case studies that we have seen, especially in the field of IPR. They are very key cases as far as Indian IPR scenario is concerned. And but before going to learn more about those cases, what we will do is we will just briefly refresh on a few points. Basically, what is IPR? What are the applicabilities in India? What are the conditions under which IP can be patented? And then, of course, we'll go into the case study. And the last part of the discussions will be summary of probably not just my session, overall workshop. And I will need your help on that. So we'll talk more about that once we reach there. So starting with the first point, what is intellectual property? What is intellectual property, or what is intellectual property right? So as it said, intellectual property refers to the creation of mind. And not just that, as per trips, I'm sure you have had a session on international guidelines as well. There are various categories of IPR. So I'm not going into the details, because as this must have been really taken into great details in our previous session. So I'm just giving a quick snapshot of what exactly they are. The categories: patents, copyrights, trademarks, geographical indications, and industrial designs. So since this is a college of agriculture, I'm sure geographical indications are very key point of or your discussions, or must be your key interest. And I heard yesterday VC sir and Professor Mulay sir did talk about those geographical indications as well. So just looking down at some of the geographical indications, especially to Himachal Pradesh, we have quite a few, and I'm really happy that not just in the field of agriculture, but we also have some really domestic customer driven or used geographical indications as well, like Chamba chappal on one end, whereas in agricultural we have Kangrati, Kala Jeera, and chili oil, right? So there is a scope, and as I think was discussed on day one opening session, we need to have more geographical indications coming out of various areas, because given the Indian situation and length and breadth, we definitely have quite a few of such specialties across regions, and definitely we need to have more GIs. So I think Bhushan sir did talk about the fact of agent. Career in IPR. I think if you can develop more GIs, it's again one of the great career building for you as well, and that too, which will give your area and your state a name in the fields of IPR. So think on that line as well. I might add as one of the careers path for this. All right. So going ahead. Is the slide moving further? I guess not.
No, it is not.
Right. So we did talk about quite a few sessions must have been discussed. What are the sections, rules of patent? So what are the patent applicabilities in India? So in order to get a patent, what is it that it takes? What are the definitive criteria or key 3 points that controller looks at when you file for an patent, right? So it's of course the novelty, inventive step, and the industrial applicability of your invention. So if we don't have that, the overall invention will not be qualified as a patent. And once it is patented, I mean, there are 2 types of patents that we can file. One is, of course, a process patent, and the other one is a product patent. And I'm sure you must have heard about TRIPS agreement in our previous session. So earlier we only had process patent, but after the TRIPS agreement, and when India became part of WTO state and signed the patents TRIPS agreement, from 2005 onwards, we also started giving out product patents. Now, yes, you have an idea, you have an invention which is patented, either process or product. Then what does it do to you? As it said, with great power comes the great responsibility. Similarly, with great patents, you also get some rights. Now, these rights are very exclusive to you for a period of 20 years. And it not just gives you a grant for only the patent, it also gives you other related IPR rights, related rights as well. And as it's said, when I think there was a question earlier, whether if you have a patent in India, can we file? Do you have an automatic patent for it across the world? So the answer is no. At least for patent is very much territorial, so you have to file it for in other countries as well. But what it does really to you is, as a patent holder, it allows you to manufacture, sell, import your patent within India and outside as well. And the way it is always said that the patent is a negative right, because it excludes others basically to do what you can do, right? So in that sense, it's a negative right, but a right nevertheless for the patentee, right? So this is what it does, and this is what the patent applicability means as far as India is concerned. Now, in next few slides, we are going to talk about various case studies, especially in real life. And I do have one case study which is very close to, will be very close to your heart, is in the field of agriculture. And I think we did talk about one gene, a question on gene as well. So we will talk about that. But before going into those case studies, I thought of refreshing some of the points and one or two key concepts in the field of IPR, and certainly why I'm taking these two, this concept, compulsory license, is because there are two case studies which are directly dependent on this particular concept. And we can see as we go along in that case study how same section or the same concept can be used in different situations in a different way, right? So we'll talk about that once we go to those slides and those case studies. But as the definition or as per section 84 of Indian Patents Act, compulsory license can be filed by any person who's interested in filing a compulsory license. So we can file this application to the controller within 3 hours, after expiration of 3 years from the date of grant of patent. And there are 3 key conditions on which controller will assess this patent. So when you file for a compulsory license, controller will see if the invention which is already patented satisfies the reasonable requirements of the public, and whether it is available to the public at reasonably affordable price or not. And the third very important condition is also whether it is worked in India. So that means whether see, the very purpose of giving a patent to a person is to say that not only to protect your rights as an idea holder, it also gives you or mandates you to work it in the field, so that you make it available to the people at large, within the country or outside the country, depending on what kind of patents you have filed. But the idea is that you take it to the people, don't limit it to yourself, because if you keep it to yourself, chances are that you might lose it on the grounds of compulsory license. Right, so these are the 3 main conditions on which a controller looks at whether a compulsory license can be granted or cannot be granted to a person who's filed it. And in addition to, this is very much a definition, but there are various conditions as well under which we can file a compulsory license. So compulsory license under section 84 is a very normal routine compulsory license, which will definitely be based on the 3 points that we discussed earlier. But there are 2 specific situations, and I would like to talk about that, because when we go into our case study, both these situations will be discussed and will be, in fact, they have been utilized by the pharma company to get the compulsory license, right? So the first one is under section 92, which gives a compulsory notification by the central government on the fact that if there are any national emergencies, or there are any extreme urgencies, or if there are any diseases for which a treatment needs to be made available to the public people of India. So there are specific diseases like HIV, AIDS, TB, malaria, or any other epidemics. And I'm sure currently we are looking at the epidemics, epidemiology, and this is an era of such epidemics, right? So people will know and can sympathize and understand what we are talking about here. So under this situation, a compulsory license can be granted by notification of the central government. So here, unlike in section 84, it's the government who initiates it, the compulsory license. And again, in the similar situation in 92A, it's the compulsory license is given by a central government, or like another body to a pharmaceutical company to export their products. So this is, I think, Mulay sir did talk about in his opening lecture about India helping the very large number of countries, especially in in the African region, in terms of treating and helping them with HIV products or malaria disease treatments, because necessarily these countries because necessarily these countries did not have the manufacturing capacity to manufacture such drugs, and hence India, under the specific licensing from WHO, helped these countries on humanitarian ground to supply the required drugs and this was a specific arrangement made with WHO from by various Indian pharma companies. Right. So these are the three sections in which compulsory license can be obtained. And in addition to these three, after this, I'll take a pause and if we'll see if there are any questions, because the next slides will definitely be on the practical case studies. So after this, we can take a pause and see if there are any questions. But in addition to the sections that we discussed, like 84, 92, and 92A, there are other sections as well in which a license or a patent can be obtained either by the government for themselves, and again in various conditions. So again in section 47, government can grant a patent in certain conditions. So in that case, import export will be allowed, but provided the government uses it for its own use. The other section, which is again could have been very much relevant in this pandemic area, is section 100 and section 102, where the central government has the power to use a particular invention for the purposes of government. So, you must have seen various vaccines are being made available during this COVID phase to the people of India. And I'm sure we are one of the topmost countries where such vaccine drive has been done. And they must, while the smaller points of that agreements between the government and the vaccine manufacturers have not been made available, but I'm sure they would have used any of these two sections, because definitely the MNC pharmas or vaccine manufacturers did have a patent on that. Similarly, probably the case would have been with our own Covaxin as well, because of course the ICMR, as you know, was part of that. So they would have utilized either of these sections to get the license for use of that vaccine for Indian people. And so these are the sections like 102, which is in natural emergency or any extreme emergency. It can be patent can be used by the government. Whereas section 102 talks about that government does the acquisition of the patent. So it no longer resides with the inventor. It's the government who owns the patent, and our Patent Act has made such clear guidelines and provisions for central government to purchase the invention outright. But of course, that's not done for government's own interest. This is definitely done only when there is a public interest, and the purchase of the invention is helpful for the government and then for the people of India. So under these circumstances, these are the relevant sections which can also be used. So I take a pause here. If there are any questions, we can talk about it here, or we can do that right at the end as well once the case studies are done. Should we move ahead?
Yes.
Okay, perfect. Right. So now we talk about the landmark case as far as Indian patent system is concerned. So as you can see, this is the first compulsory license that was ever granted in India. So this was granted in March the 9th of 2012. And it was granted to a Indian company called NATCO. There was a case against Bayer, and of course this was a non-COVID situation, since this is in 2012. Let's go into the details of this case. So what happened is Bayer, a global MNC company, had a patent on drug called sorafenib tosylate, which was used for the treatment of kidney and liver cancer. And this drug, whose brand name is Nexavar, was launched in 2006, and the DCGI, or the Drugs Controller of General of India, allowed its import into India on 1st of August 2007. So one thing is very clear, that it was available to Indian people from 2007, and Bayer had the patent. Now moving into the next stages, what happened is, as per the patent rule, you have to give an information about your patent as to what extent you have worked that patent in India. And then it was realized by NATCO that around 2009, 2010, in that calendar years, Bayer did not import any drug certainly not in 2008, but in 9 and 10, very less quantity of that drug was imported into India. Seeing this, NATCO probably started to develop its own process to manufacture the same drug. And in 2011, it got the license from the ministry to manufacture that drug. So now imagine there are two situations here. One is NATCO developed its own process, and at the same time, Bayer did not have too much of drug into India to supply to the Indian people. And seeing this, that Bayer is not very keen to make the drug available to more people in India, NATCO actually filed for a compulsory license. And the result is that on all the three grounds, that is, the patent is not worked in India, patent is not made available at affordable price, and the third one is the patent not used in India, Controller General allowed the compulsory license to go through, and it awarded its first compulsory license to NATCO in 2012. So this is a classic and first of its kind as far as India is concerned, and it happened in the pharma sector. And the specific section under which it was advanced by NATCO was under Section 84. Right. So remember these two sections because in next slide that we are going to talk about, the situation is entirely different. Right. So in the second case, again, incidentally, it was NATCO who was at the center of this compulsory filing. First, it was an emergency use for a drug called baricitinib, and this was in a COVID-19 situation. Again, NATCO filed for emergency use approval for treatment of COVID, and eventually they applied for compulsory license. So that's the story so far, right? And going more into that story and details, this drug which is called as a JAK inhibitor, is used for treatment of rheumatoid arthritis. The patent was held by Eli Lilly and Company and a brand name of the drug was Olument. Again, it was approved for use of treatment of rheumatoid arthritis in India in 2018. And then what happened? Then again, COVID happened, as has been the case for last 1.5 years or so. COVID happened, and then there were, because of the mechanism of the drug or its action, the drug was put under clinical trials, where in combination with remdesivir, it was tested, and what was found that baricitinib plus remdesivir as a treatment combination works much better than remdesivir alone. Right. So seeing this, NATCO again filed for emergency use approval for this baricitinib drug for the treatment of COVID. So remember, earlier the treatment was for rheumatoid arthritis, but now it's for the treatment of COVID with remdesivir. Right. So this is a different setting, and what we call in our pharma language, it's called as a repurposing of the drug. Why repurposed? Because it was basically used for, or when it was patented, it was used for the treatment of rheumatoid arthritis, but the same drug was then later found to for the treatment of another disease or another indication. So the story so far here is that NATCO filed for EUA, and as we know, we have heard EUA for such a long time in this last 1.5 years. I think everyone is aware of that. So this is emergency use was given for this particular drug, and seeing that there is a situation of national emergency, extreme urgency, and again epidemic, NATCO filed for a compulsory licensing of this very drug, that is baricitinib, on 3rd of May in 2021. And this time, see this difference. That's what I wanted to remember. First was a section 84, and here the section is different. It's section 92, and especially with 92.1 and 92.3, which talks about such national emergencies, extreme emergencies. So a great example really of how you can use different sections, different situations to your advantage to get to the same result. So here the result is getting a compulsory license, but in first case, since there was no epidemics, no national emergency, it was a proper section of 84 which was advanced by NATCO, saying that it is not being worked and etc. on all the 3 conditions. And the third, in this case, since there was a COVID era pandemic, they advanced a different section and different conditions. Right. So as we say colloquially, it's horses for courses, right? So it's like, if you need to score 10 runs in 2 balls, you will not send Cheteshwar Pujara, right? You will definitely send Kharan Pollard. So this is exactly the case of that. Horses for courses, using different sections at different points of time. And again, it's the same company, NATCO, right? So probably NATCO seems to have some real good people who know the IPR very well, right? Because these are the 2 cases where NATCO is involved, and on 2 sides of the pandemic and 2 different sections. Right. So we are talking about, why I basically wanted to show this slide is because we did talk about the fact that patents are negative rights to an extent, saying that it does not, or it excludes others for doing something what only you can do, right? But in some cases, keeping the humanitarian grounds in mind, there are companies, especially in COVID era, did let off their IPR rights. So companies like Gilead, who has the patent for remdesivir, company like Medtronic, who had a patent for a ventilator, and Moderna, again for COVID vaccine, they let off their IPR rights and said that keeping in mind the situation, we will actually give our IPR without any cost, and they signed a voluntary agreement with various companies, including Indian companies, for getting this drug into India and making it available to the people. So I know this is not direct case study, but I thought of bringing it because you can use this in different conditions, and people, it's not just about making money or excluding others. Sometimes people have worked in this fashion as well. So just to show how people can react in epidemics and pandemic situations. So this was all about first 2 slides and 2 case studies, basically on the compulsory licensing and what can be done on using compulsory licensing and various sections. In next 3 to 4 slides, we are basically going to talk about some definitive examples of section 3, which talks about what are the inventions that are patentable and what inventions are not patentable. The first slide is on the traditional knowledge, and very close to not just the students of agricultural college, but as Indians, it becomes very, very important for us to protect our traditional knowledge. And the reference of this was also made, I think, either by Vice-Chancellor Sir or Mulay Sir in their earlier discussions. You would have guessed it by now. It's a Haldi patent, which was filed by University of Mississippi in 1995. And they used it for, the subject matter, as it's called, of the patent was the use of haldi in wound healing. Now, coming to know of this, Indian Council of Scientific and Industrial Research, that's CSIR, and specifically led by Mashelkar sir, we filed for injunction and revocation of this patent of haldi, saying that this has been used in India for centuries, and the team led by Mashelkar sir actually did extensive research and could actually show the 32 references in different languages like Sanskrit, Urdu, Hindi, showing the length and breadth of use of haldi across India, and for long term, for long periods of time, actually centuries. So saying that, taking the leaf out of, again, what Bhushan sir presented on from Donald Duck cartoons, it fell in the region of prior art, certainly not in funny way as it did in Donald Duck comics, but here it was a real use. So as it's a prior art, use of haldi as antiseptic was or wound healing was a prior art. USPTO, that is US Patent Office, revoked the patent on saying that it is obvious, it is anticipated, and giving the preference or the traditional knowledge of India the benefit of the fact that it's being very much used in the country for a long period of time. Same thing happened with neem. Again, another company, only the teams have changed in this case. The story remains the same. It's W.R. Grace company which filed for the patent in Europe with European Patent Office, but this time it was for neem. And they said that it's a fungicidal activities of neem against which they filed a patent and formulation, again in agriculture. But again, the same thing, our team from our various Krishi institutes came together and showed successfully that neem has been used for very same indications, very same activities for long periods of time, in fact centuries. So when this was given to EPO, EPO identified that the patent presented on neem lacks novelty, it does not have any inventive step, and again has a prior art available, and then it revoked the patent. So very close to our field of not just India, Krushi as well, but very much related to India as well. Right. So I thought of bringing this slide and this case study for our discussion so that we kind of know that such things are also happening and we can protect our traditional knowledge. And So, and that's the reason why I think we must give importance to GI, because if we have GI as well, some similar things can also be prevented for in terms of filing the patent. Now, so the next case study is in the field of business method, and very technical at that. It's again a very landmark case as far as Indian scenario is concerned. It's a case between Rediff and Yahoo. The story here is that a company called Overture Services filed a patent for a very mouthful name called a method of operating a computer network search apparatus. So basically, it was a search engine, if you can say it that way. So it was a search engine for which it filed a patent. And by the way, this Overture was then bought over by Yahoo. And this application or this patent had an application similar priority claimed in US in 1999. Then when you have heard about various stages of patent examination, right? So when it came to the examiner to review the patent, 17 objections were raised, and specifically under section 3K, which talks about business method, saying that this patent is not valid, and it was sent to Yahoo for their responses. Actually, Yahoo did a very brilliant job in defending their case, and the responses were, they amended their responses and their claims to the effect that examiner actually felt that yes, we can grant a patent. As you can see here in claims amendment, IPO informed Yahoo that yes, we can grant you patent provided there is no pre-grant opposition. And next, as IPO said this, Rediff in 2007 filed a pre-grant opposition against this claim of Yahoo in the same using the same section of section 3K of business methods. And the outcome is that the court actually held that the Rediff's objections were correct, and the subject matter does fall under business methods under section 3K, and hence the patent is not valid. I'm very categorically quoting one line from IPAB's discussions on this case, and when they actually made the final decision, this is in the public domain as well, and this is what they said. The exclusions, and I'm reading out the way as it is, right? So quote unquote, the exclusions are carved out for all business methods, and therefore, if in substance the claims relate to business methods, even with the help of technology, they are not considered patentable. I think this is very strong statement and very clear statement indicating what is patentable and what's not patentable. So basically, if it's a business method, computer program, algorithm per se, even with the help of technology, they still fall under 3K and are not patentable. So this is a very strong statement, but at the same time, very clear indication of how you can draft your claims or how you should draft your claims. And as we were discussing earlier in earlier slide, you must think assess yourself. What's the patent like? What the idea that you have, can that be a patentable idea in first place? So this was in technical field in section 3K. While we have been talking about patents, IPR and patents is one part of IPR overall. So I'm going to talk about one specific case which talks about infringement, and it's a very sweet case, really speaking, because it talks about Maaza and the mango drink, basically. As we know, this was earlier owned by Bisleri and then later on to Coca-Cola. So what happened? The story here is that Maaza was acquired by Coca-Cola from Bisleri in 1993. So it was not just, so what did they buy? Did they buy the crates of Maaza or several thousand bottles? No, they actually bought the IPR and the trademark, goodwill, everything related to Maaza. And that's why I said, if you remember in my first slide, we talk about IPR related to the invention, right? So this is also an IPR related to the invention. So even the goodwill is a part of this entire IPR and intellectual property, right? So the story so far here is that Coca-Cola brought Maaza from Bisleri in 1993. Then everything was fine, going on smoothly. People were drinking Maaza in India. Bisleri probably felt very troubled because of that, and they decided to go international. And they filed for a copyright for Maaza in Turkey in 2008, right? So actually around 15 years or so, everything was going on perfectly fine. And then suddenly in 2008, Bisleri filed for its trademark in Turkey in 2008. And not only that, not only just application, it also started exporting. So crates were sent to Turkey with brand name, with trademark, brand name, and bottle, everything of Maaza to Turkey. Now Coca-Cola got to know of it, right? Again, as has been the case in every such things, against as far as IPR is concerned, you go to court, right? So here again, court mein tarik pe tarik. So what happened is Coca-Cola filed for infringement case against Bisleri. Now Bisleri particularly advanced their arguments, saying that uh, they have licensed Maaza as a trademark worldwide. So they have the right to sell it across the world uh, without infringing on Coca-Cola's right, which are more territorial in nature. Because remember, the agreement between Coca-Cola and Bisleri was for the rights in India, and Bisleri assumed that yes, these rights will limit only to India and will not have its purview beyond India. They were probably right in their thinking till the ruling came in, and this is where probably Bisleri did not take into the consideration of the difference between goodwill, copyright, and patent. Patent is very much territorial, whereas copyright, as the ruling says from the Delhi government, that Bisleri should stop all manufacturing and usage of trademark plaza with immediate effect in Turkey as well. And with this ruling came really three key points that we can understand. Is trademark with other associated IPRs is also very integral part of intellectual property rights of an invention. That it's a global phenomenon, and it protects the proprietor across the world, and it does not matter really whether you have an agreement in India or outside of India as well. So that's the essence of this case, and I thought of bringing this point again. So far in our previous slides, we had discussed only about patents, right? So but this is a different part of IPR, which is copyright, and that's a very specific reason why I thought I have brought this slide in our discussions. And it basically says that it's a global phenomenon. It doesn't limit to India. So goodwill can be taken outside of India as well. Now, this is the last slide on the case study. And again, this is very much closer to your group, agricultural students, and a specific section of 3J. I will read out the section first. It says that plants and animals in whole or in any part thereof, other than microorganisms, but including seeds, varieties, and species, and essentially biological processes for production or for propagation of plants and animals. You may feel that this is an only the part of the section, but section itself starts with the lines that what following are not patentable, right? So at the end of it, what we have to understand, all this, whatever is mentioned in these two lines, is not patentable, and this is section 3J. So this was a specific case between a company called Monsanto and Indian company called Nuzivedu Seeds. Now we'll go. So this is a very tricky, very lengthy, and there are many discussions between the I mean, there are a lot of arguments in the courts as well. So I'm breaking it down to a very specific area. We'll concentrate on that first. And as we move along, we will talk about it in the totality, right? So to start with, Monsanto had a registered patent on a nucleotide acid sequence, NAS as it's called, for a gene called Bacillus thuringiensis, that is BT gene. So there was a question, right? Someone did ask whether a synthetic gene can be patented or not. I think by the end of this slide, we may have an answer, or we may not have an answer. So we'll look at that. But this is probably in the similar area that the question was asked. So I'm happy that I could cover some of the questions as well right up front. Right. So this was the case. Monsanto had a patent on this BT gene, BT cotton specifically. So what it does is that on insertion into DNA of the cotton seeds, this NAS, this sequence, killed bollworms from inside the seed and therefore reduced the dependence of insecticides and pesticides. So that was the technology. And Monsanto transferred this technology through a sub-licensing agreement to various seed owners, seed manufacturers in India. Nuzivedu was one of the companies in that. And under this agreement, they, as always, the patents are for getting the money as well. So these seed manufacturers had to pay a royalty to Monsanto, what is called as a trait fee. So once that is done, Monsanto kind of raised their trait fee, and to which our seed manufacturers opposed. So what happened? And that's when the dispute started and the petition started. So while extending the agreement, Monsanto prescribed a higher fee than the statutory limit or the statutory fee. Nuzivedu paid only what was lawful. So it paid the statutory fee, but declined, and many others declined to pay the additional fee that Monsanto was looking for. Now, aggrieved by this, Monsanto terminated the agreement, and in 2016 they filed for an patent infringement case against all these seed manufacturers using their brand name, and basically again asking everyone else to stop using their patented technology called Bolgard and Bolgard 2. Now here comes the relation to the Patent Act. Right, Nuzivedu in its counterclaim said that the patent that that Monsanto has is invalid, and they specifically gave a reference of section 3J, which talks about the plants and seeds. Now, so far there has been just disputes, but we'll now look at what are the arguments. I know the slide is full of text, but I thought of bringing some of these points very categorically, because the arguments were progressed in scientific, agricultural, as well as in legal way, that it has a lot of bearing on the outcome and the final decision by the honorable courts, right? So Monsanto, in its defense, argued that the NAS is a microorganism and hence it's patentable under the act. So under this act 3J, it further argued that they are not seeking a patent for the plant itself, but they are seeking a patent for the NAS or the sequence, basically, right? And they further argued that, again, synthetic gene that we talked about, they said that this NAS did not occur in nature and a manual intervention was required to create this, and that's what they were claiming for. So patent was basically for the creation of NAS and not on the plant itself. Okay, so far the story was fine. Then Nuzivedu in its counterclaim said that, and this is why I'm bringing it up in great details here. Nuzivedu said that on its own, uh, the NAS is not capable of industrial production unless it is inserted in a seed. So they basically said that NAS itself is not an patent or can't be used unless it is coupled with the seed, right? So that's the claim. And as they said that as the gene got transmitted to the progeny, you will have to sorry, you will have to treat this NAS along with the seed, and it definitely becomes the section valid in section 3J, right? So this is what the overall arguments was, and the case was first directed to Delhi High Court, where Delhi High Court said that yes, prima facie we feel that the patent is valid. So Monsanto's right on the technology was held by Delhi High Court. Not satisfied with the decision, both the parties moved, especially Nuzivedu naturally, moved to the division bench of Delhi High Court. And here, in a very interesting manner, Delhi High Court revoked the patent, saying that this is definitely case under 3J. Because of the very fact of how Nuzivedu claimed and counterclaimed, basically, right? So division bench said that this is not this is a valid patent, and they revoked it. Again, not agreeing to the decision, Monsanto moved to Supreme Court, and in 2019, Supreme Court said that the question of validity of patent is mixed question of fact and law, and therefore evidence of an expert testimony has to be considered. And it then again took the case back to the Delhi High Court. So it was again remanded to Delhi High Court, and with a specific question that we have to decide whether the NAS becomes part of the plant or seed after insertion or not. So if it does, if the answer is positive, that means if it becomes the part of the plant or seed, then it is no longer under the Patent Act. It becomes a case of Protection of Plant Varieties Act. I think there was a discussion on day one about patenting of plant varieties as well. So, we can link this case again to that question as well, that if the overall technology doesn't become plant or seed, then it is a part of PPV Act. And if the answer is negative, that means if NAS becomes the part of the plant or seed and the answer is no to it, then it will fall under 3J, and that's when we'll have to decide whether this is a patentable invention or not. So after moving from, say, 2016 till this point in time, that's again in 2022, the case is actually pending in with Delhi High Court on the final decision. But great points being discussed, and various objections were forwarded specifically using this section 3J, and I think it kind of puts gives us a great story and case study as to what is it that can be done, what can't be done, and how you can progress your arguments in what manner. So this actually is the last slide on the case studies, so this actually completes my presentation. But as has always been the case, there has to be a summary. So what I want you people to do in order to make a summary of not just this session, but probably the workshop of last 2 days, start putting in the chat box the 2 key takeaways or 2 key learnings from yesterday and today's session. So that means what, in your opinion, are the key learnings that you got out of this workshop? Because I think the objective of this workshop is not to give just the gyan, right? It's to make you gyani, really. So what is it that you have taken out of this workshop, and what is it that you will probably keep in your mind throughout your life as far as IPR is concerned. So start putting down these two points in the chat box while I give you some more information on. Hope you have started. I'm not able to see the chat box, but hope you have started to put down those points. Yes or no? If not, then please. And while you do that, there are a couple of points or a couple of statistics that I want to put here. That ये सब तो हम लोग ने सुन लिया, सेक्शन सुन लिए, regulation सुन लिए, but where is India? Where is India in IPR scenario? I think Bhushan sir did make a reference of that of a global innovation index. So this is the latest survey of Economic Survey of India released in 2022, for which India is now on rank 26. It has moved around 35 places from 2015 till today, and we are sitting on number 46. You can also see the number of patents that have been granted from 10-11 till today. So in the space of around 10 years, we moved from 7,500 to 28,391 patents, which are granted patents, right? So as of today, these are the patents that are granted. Again, the number of patents filed in India moved from 39,000 to 58,500 from 2010 to 2011. So in the space of 10 years, again, the numbers have almost doubled, if I can say. If not double, at least 1.5 times been risen. And again, I think this figure is particularly makes me very proud and very happy that 40% Indian residents have made the total applications in 2020 or 2011. So if you look at the number of patents filed, the 40% patents are from Indian residents, and this really takes us closer to the Atmanirbhar Bharat and all other activities, all other initiatives that government is trying to put for ourselves in this area. And lastly, it's not just us, right? We need that government support, government vision. So I really want to quote from Piyush Goyal's, our Minister on Commerce and Industry, his statements, which he made at an annual event in 2021, where he conferred on the National Intellectual Property Awards. And what he said is pretty important, I think, very relevant and very encouraging as well, is that IP, that is intellectual property, has the power and potential to change lives and create livelihoods for billions. Powered by intellectual property, India can be the innovation powerhouse of the world. So these are the words of a minister. By the way, not just anyone else, not industrialist, not technocrat. It is the word of minister. And I'm sure those who know Piyush Goyal's credentials, he's a technocrat himself. So really not surprising that it's coming from him. And we must aim to make India the design hub of the world. And intellectual property is the key for success of Startup India, Make in India, and Design India. So not stopping at that, I think several references were also made to, even in our previous lecture by Bhushan sir on budget and the activities and various initiatives. So the ones which are probably closer to you would be Krishi Startup, support to that, and Kisan Drones. I